everybody, Dan here, Scootering Magazine, and today we are joined by Stephen Hattersley of WildWood Legal. WildWood are a specialist law firm who cover a number of areas, but one of their specialist departments is helping scooterists. Stephen is a scooterist of 30 plus years and has a regular column in the front of Scootering Magazine. I'll pop some links to subscriptions and single copy deals in the comments below. And if you have any questions that you'd like to ask, then just check out the column in the front of the magazine. Stephen's email is in there. I'll also pop that in the comments below. And then if you have any questions that stem from these videos, feel free to send them in. Okay, we'll jump straight in and we're going to run through a series of questions which quite often crop up from scooterists and see what answers Stephen can give us. We had one chap write into the magazine and he'd had an accident, but he'd had it a while ago. And at the time, he just didn't believe that he was in a position to claim. He later heard of a chap he knew who'd had a similar accident and claimed. So in terms of timescales, could he then go back? What is there a statute of limitations? When is it too late to make a claim?
Well, generally, if you're over 18, it's 3 years from the date of the accident. By that time, you need to start formal court proceedings. Now, you can't just tip up at a solicitor's a day before 3 years is up and say, I'd like to make a claim, because there are various steps that need to be taken before those proceedings can be issued. A lot of firms will have a policy that if there's less than 6 months to go before that 3 years is up, they won't even look at the case. I had a really good case come to me a couple of months ago. All was going well, I was taking a load of notes about it, all seemed fine. They gave me the accident date, and it was about a month before the 3rd anniversary. And as good as it was, I just couldn't take it, because you never know what the defendants are going to come up with in response. You need to get medical evidence together before you can get the proceedings served on the other side. And there are a lot of steps you need to take. And it was just too near the deadline. I couldn't take it. I try and be as flexible as I can, but sometimes it's just too close. You just can't do it. So if you do want to make a claim, then yeah, there's no harm in speaking to someone early on and getting the groundwork done at that stage.
Yeah. But yeah, predictably, the longer you leave it, I suppose the harder it's going to be.
Well, you're looking, if you've got witnesses to it as well, a lot of people won't like being witnesses. If you're going to get them to be witnesses, you want their evidence to be as fresh as possible. So if there's going to be any kind of dispute on liability, then you need to find out what their evidence is going to be. If you've getting in touch with someone a couple of years after an accident, the chance of them wanting to cooperate and be helpful, A, will have reduced, and B, the effectiveness and efficacy of their memory is probably going to be a bit reduced as well. So yeah, there's no benefit to delaying it, to be honest.
I guess this is where somebody like yourself, your WildWood services really sort of stands out. This chap says, my solicitor wants to take 25% of any money I get from my accident compensation. Is that allowed? It doesn't seem fair. What's your opinion on that?
It's still slightly strange to me, because I've been practicing for 26, 27 years. And up until 2013, he never took any money off clients. We get paid our cost by the other side, and that was by the defendants, and it was simple as that. The law changed then. It very much cut down the cost that we could charge from the defendants, but it opened it up to the more American system where we take a percentage of the damages. Now, the maximum that's capped at is 25%. So solicitor can't legally take more than 25%. We very rarely take 25% because I think it's too high. We certainly cap it for anyone who mentions scootering when they come to us. And we try and charge lower than that, because if we think it's a decent case, we're going to get some costs on the other side, and we'll take what we think is a fair success fee. But yeah, if it is normal now, and I think I'm right in saying that I think 100% of firms will charge a success fee.
Right.
But it's just a question. It can be flexible. 25% is the maximum. A lot of solicitors have taken it that, right, 25% is our standard, and that's what we'll always charge. I don't think that's right, to be honest. We'll look at each case on its merits and see what we think is a fair amount.
Just two more questions for this session.
Sure.
Then. A lot of scooterists tour overseas. Now, in the event that somebody's knocked off or injured, say in France, for example, what is the process? Are they trying to fight a case over in France? Do they expect their UK insurer to fight their cause for them? What's the process here?
Well, I'm going to give you a response to that, which I think is accurate, but I don't know whether this has changed post-Brexit or not. I think we're still in the transition phase on this. But basically, the good news is, under European law, you don't need to instruct French lawyers in that situation. You can have the claim dealt with in this country with English solicitors. Obviously, you need the solicitor going to know the way around that legislation because it is a bit fiddly and there's various steps you need to follow. So make sure you get in touch with the specialist solicitor if you can do that. Whether that will change post-Brexit, I don't know, but I'm fairly sure we're still in the transition period at the moment. So that's still sort of good advice that you can use your English solicitors because, yeah, it wouldn't be the easiest thing in the world going and getting instructing French solicitors and taking it from there. I'd wish anyone well if they're trying to do that.
And the last one is a couple were knocked off their scooter and both him and his passenger were injured. It says it wasn't his fault. How come you can't act for both of us?
Well, it's in the client's interest that we don't, to be honest, because as much as the rider may be convinced it wasn't his fault, if we start acting for both of you, then if we get a defence back from the other party saying that it was partially your fault, that would then mean we'd have to stop acting for both of you because there'd be a conflict of interest. So what we tend to do, we'll act for one of you first of all, with the other one we'll tend to take the case on for the rider. We'll see if we get a full admission back from the defendants, then that means we can then act for the pillion passenger as well because there isn't any conflict of interest. But otherwise, if we're acting for the two and there's an argument raised by the defendant that the rider was partially responsible, then we're not giving you the best service we can if we act for both of you because there's a chance that even if you don't like that outcome, there is a chance that the rider might be found partially liable, and that would mean that you're arguing between themselves and we can't be acting for two clients where there's an argument between
So even though they are a couple, it's about sort of almost hedging your bets and...
Yeah, if it's clear-cut on liability, I'll just say to them, look, we'll take on the rider's case first of all, see where we get. If we think we're going to get an admission and we get that admission through, then we'll take on the pillion passenger claim as well because there's no conflict of interest at all. Yeah. Both are sort of arguing the same thing against the other rider.
Yeah, fair enough. Is there anything else that you want to add, Stephen? Anything that you think scooterists should know? Any common problems or anything about your particular business or line of work?
We're always here. We get quite a few queries about various things. If people want to ask us something with a legal question or just generally about scootering, we're happy to deal with them. It's our contact details are in the magazine and always happy to help whenever we can. Any questions at all.
Great stuff. Well, thanks very much for your time. I'm Dan Clare,
no problem,
Magazine.
Pleasure.
You're Stephen Hattersley, WildWood Legal. See everybody on the next video.